Hey, hi there. It's Neil Christiansen, and welcome back to another episode of the Mile High Market Talk podcast, where we bring local professionals to the stage for them to share their expertise and to educate our clients to help them continue to build their overall net worth. In today's episode, we are going to be explaining the importance of estate planning and why it's relevant for all listeners, no matter what age you're at or financial status. I'd like to introduce the local guest today, which is Will Morris with Bond and Morris PC. Will's focused practices on estate planning, probate, trust administration, and related income tax, gift tax, and estate tax matters. Will is a native of Colorado, and he enjoys playing tennis, skiing, and hanging out with his family. So whether you're just starting to accumulate your assets or you have a lot to account for, estate planning should definitely be part of the overall financial plan, just to ensure that you and your loved ones are protected as life goes on. So without further ado, I'd like to introduce Will. How you doing today, Will?
Great. Thanks, Neil. Thanks for having me.
Absolutely. Absolutely. Well, like I said, I think this is a topic when I bring it up with clients, they always kind of scratch their head like, well, I'm still alive. I don't really think this is something that I need to pay attention to. But as we all know, when that unexpected happens, it's best to be as prepared as possible, to avoid the lengthy probate that sometimes can take place. So I've generated 3 questions for you here, Will. Let's go ahead and start with the first one. So key estate planning documents. What are the essential documents that every individual should have in place? Consider discussing some pitfalls, some strategies, and if there's any relative local news that you might want to share here in Colorado.
Yeah. Great question, Neil. And so the key estate plan documents, number one is to have a will. The will is the document that simply says, okay, if you were to pass away, where do assets go? Who is in charge as your executor, your personal representative to pay last debts, pay last taxes, and make sure your assets go to the legal beneficiaries. So will is the number one document. The number two document in there that is used in a lot of estate plans, not necessary in some, would be a trust. And the main purpose of having a trust, which would be in conjunction with also having a will, is number one, to avoid probate, which probate is the court system of transferring assets when a person passes away. If you have a trust, typically you can avoid probate, so you avoid court and the probate process. And so that trust would be kind of the number two document. Number three would be a financial power of attorney. Powers of attorney deal with your incapacity, where a will and a trust deal with your death. A power of attorney deals with your incapacity. So if you're incapacitated, you couldn't make financial decisions for yourself. The agent named on your financial power of attorney could make financial decisions for you. The next key document would be a medical durable power of attorney. Same concept as the financial durable power of attorney, but obviously this is for medical purposes. So if you're incapacitated, you can name an agent under the medical power of attorney to make those medical decisions for you if you couldn't make those decisions for yourself. And then the last document that's kind of in the key core estate planning documents here in Colorado would be an advanced directive. It's also known as a living will. For lack of a better term, that is the pulling the plug document, where typically a living will says if 2 doctors certify in writing that you're in a permanent or a persistent vegetative state, you're allowing the hospital, allowing the doctors to pull the plug, and you can put, a time limit on it. You can leave that decision up to your agent under the medical power of attorney. But those are really the key documents: the will, a trust, possibly a financial power of attorney, a medical power of attorney, and an advanced directive, the living will.
So is there a separation between will and trust? I mean, it sounds like everybody should have a will, but what makes somebody decide, let's get into a trust? Is it assets? Is it just personal preference?
Typically it's asset driven. So the number one driver of having a revocable living trust would be if anyone owns real estate, real property outside the state of Colorado. So if you're a Colorado resident and you own real estate outside of Colorado, then you it's almost necessary to have that revocable trust. Other people also like a trust. Maybe they don't own real estate outside the state of Colorado, but they have, financial accounts and a business interest. They have assets that are a bit segregated or separated where they can pull it all under one umbrella, being that trust. And then a trust also comes in handy if there's minor children involved as beneficiaries, or there are adult children, but maybe they're not financially mature enough to handle an inheritance immediately. So a trust is a good way to, get assets to a beneficiary, but maybe not just a giant lump sum all at once when the decedent passes away.
Okay. And you said the difference, or maybe not the difference, but there's the will and there's the trust. If one has just a will, can they also avoid probate, or do they have to have a trust to avoid probate?
You can. So yeah, it's a little trickier when you just have a will, but you can avoid probate by having a will, but you have to make sure that financial accounts have the proper beneficiary designations assigned to them. So you're naming beneficiaries on financial accounts, or transfer on death designees, so TODs, payable on death. So all your financial accounts have beneficiary designations, PODs or TODs attached to them. And then your real estate has to have what's called a beneficiary deed attached to it, or it has to be jointly owned with someone who survives you in order to transfer without going through probate.
Okay. And is probate as bad as it sounds, or some of the
No.
experiences that people have gone through?
Yeah, great question, Neil. And so probate is very state specific. And so I can only speak about kind of Colorado's probate system, but Colorado, over the past 15, 20 years, has made it more efficient. So, the long and the short of it is probate is, filing some paperwork with the court saying that someone's passed away, this is who their closest living family members are. This is what their will says if they have a will, or if they don't have a will, you kind of just explain to the court what's going on. And then there's a time period of waiting for the court to review all that paperwork, to issue an order allowing an executor, a personal representative, to start distributing property to the legal beneficiaries. There's a little bit of expense and a little bit of time here in Colorado for the probate process, but it's not the end of the world. In California and Florida, for example, those are two states where to go through probate, if you get represented by a probate attorney, the probate attorney takes a percentage of the assets that go through probate. So it's very, very expensive. Here in Colorado, it's relatively cheap compared to other states. And so that's just something to keep in mind with California and Florida. And there's some other states where if you own property in those states, you almost have to have a revocable living trust and have those properties owned by the revocable living trust.
Nice. So it does sound like, if there was a will put in place, or if there was a trust put in place, to just avoid probate and to kind of get that time back, because I've heard that even here in Colorado, it can be as long as a year if it's kind of a complex estate type situation. But it also, from what you're saying, in other states can be a nightmare to get through it, as well as the attorney taking a percentage of your assets that you really never anticipated probably having to pay out.
That's exactly right, Neil. Yeah, any estate plan attorney, probate attorney is going to tell you, that probate should be avoided. But I wouldn't, I have clients who lose sleep over avoiding probate, where it's not the end of the world here in Colorado if you don't completely avoid probate. But if you can, you probably should plan to avoid it.
Great. So some of the key takeaways is definitely, it just sounds like, even at the minimalist is to have a will, or to at least to consider a will. And I was going to ask, an attorney is probably going to be the best place to ask the questions and to make sure that the will is in good place. But can people do a will, let's say, online?
Yeah. People can do a will online. They can, a person can write their own will by hand. But yeah, the best advice, as an attorney, is to get an attorney to at least review what you've done, or to hire an attorney to write it themselves. Wills do need to be, in Colorado, a key thing is they need to be signed in the presence of a notary and two witnesses, where we see a lot of kind of homemade wills or those LegalZoom type templates. They're generated, but they never get signed in the presence of a notary and two witnesses, and they're not legal without that notary and two witnesses, which is vitally important.
Okay. All right. Well, good. So obviously we're encouraging people to at least get into something as simple as a will, just to make sure that you're protected with the assets that you're continuing to accumulate. Also that real estate piece, that was interesting. And then if you want to get to that next level, which would be the trust, to easily avoid probate, along with the other documents that you suggested, that all makes sense. So question number 2 is, planning for that unexpected. So how can individuals ensure that their estate plan remains effective over time, number one, and then share some insights on updating documents, legal considerations, and some local nuances if that exists.
Yeah, no, good question, Neil. And so keeping estate planning documents up to date is key. So the idea is, number one, you get the foundation in place, you get the will, you get the powers of attorney, living will, you get that all in place. And then what we do as a firm is we send out, an annual mailing to our clients, just kind of, hey, has XYZ happened to you in the past year? Just kind of jog your memory about your estate plan. And if, something on that list, strikes a chord one year, clients reach out to us, and then you can just do simple amendments off that foundation as life goes on, which are very easy to do. And typically clients are just kind of changing who their executors are, who their agents under powers of attorney are. And so those are changes that typically attorneys don't even charge for now. It's just kind of popping names in and out of documents. But at the very minimum, what we recommend to our clients is that if we haven't talked to you in 3 years, we should at least jump on a Zoom or a phone call and walk through the estate plan and make sure it's up to date if we haven't talked in 3 years. And then other considerations, a very important thing that clients constantly need to scrutinize are beneficiary designations on retirement accounts. So 401ks, IRAs, brokerage accounts, checking, savings accounts. When people set up new accounts, they sometimes forget to name beneficiaries on those accounts, or they set up a life insurance policy that still names an ex-spouse as the primary beneficiary. And so those types of issues can have very serious ramifications if they're not up to date, where what your beneficiary designations say on financial accounts, life insurance, that supersedes what your estate plan, what your will and your trust say. And so it's vitally important to make sure that beneficiary designations correspond with the will, with the trust, and with your intentions, because we see it all the time where, someone passes away, they forgot about the IRA or the life insurance beneficiary designation, and it names someone that they didn't mean to have in there.
Right.
And legally we're handcuffed, and it's an uphill battle if that's the issue.
Yeah. Well, that makes me think too, because people definitely will get a fair amount of jobs throughout their lifetime, and they set up a 401k here, 401k there, and then they might do a rollover and so forth. But the last thing that they're probably thinking about is, who was my beneficiary when I set it up 10, 15 years ago? And then if that person's even in your life, or, if it makes sense to have them as the beneficiary. I mean, that's a great point to say that if who's ever on that document will supersede anything that your will or trust suggests, that could be a game changer with an account that's been sitting dormant for maybe 10, 15 years, but has grown several, maybe thousands of dollars. The person that thought they might be inheriting it, they're not going to get it. So that's a great point that you bring up there.
That's exactly right. Yep.
All right. So again, it just sounds like just because you do a will or a trust, you don't want to necessarily forget about it. And it sounds like you guys provide kind of an annual document that just says, hey, what's going on? Has there been any changes? No, great. If so, let's maybe jump on a phone call to kind of go over that real quick. That really is kind of what will keep the will and the trust in place, and making sure that it's a good document. So should something happen, anybody that's within those documents will definitely get, the inheritance, or however it's been decided in the wills and trusts, is what I'm hearing.
Exactly right. You got it, Neil. Yep.
Great. All right. So final thoughts, preparing for the future. What actionable steps can listeners take right now to get started or improve their estate plan?
Yeah, I think just asking themselves key questions where, key questions to ask yourself. Number one is, okay, try to think about if you pass away tomorrow. The idea is, okay, God forbid, if you're gone tomorrow, what does that look like for you? I see clients too many times kind of looking too far down the road, where they try to project their death, 10, 20, 30, 40 years down the road. And, the future is too uncertain. So the idea is, okay, God forbid, if you're gone tomorrow, number one, who do you want your assets to go to? And do you have an estate plan and beneficiary designations that reflect those intentions of, okay, who do you want everything to go to? Number two is, everyone who you're naming as a beneficiary or that you want assets to go to, are they mature enough, old enough to handle that inheritance on their own? If you're gone tomorrow, are you okay with them getting a check in X amount of dollars as a beneficiary, and they can do what they want with that? Or do we need to, put it in a trust and have some safeguards around it to make sure the inheritance helps that beneficiary, doesn't hurt them? We see a lot of times when trusts aren't utilized, a client, or a beneficiary of a client, receiving, too big of an inheritance at too young of an age, or they're not mature enough to handle that, and it's not used as wisely as it could be, and that inheritance hurts them and doesn't benefit them. Those are two huge considerations to think about at a basic level. And then number three, and we've talked about it quite a bit, is kind of, okay, we want everything to flow as efficiently as possible, which means, keeping it out of the court system and avoiding probate. But number two, we want to also make sure everything passes as tax efficiently as possible. And I won't bore your listeners to death with taxes and get too deep in the weeds on it. But just a brief overview of where we are estate tax wise is a married couple right now can pass $28 million estate tax free. An individual can pass $14 million estate tax free. And so these are very high exemption amounts where most Americans, aren't going to have an estate tax problem. The more important tax that they should be worrying about would be from a capital gains perspective, where when someone passes away, their beneficiaries get what's called a step up in tax basis to the date-to-death value of the asset. And so it's very advantageous for someone to pass away owning assets and then their beneficiaries getting that step up in tax basis, where if they were to sell that asset, very little or no capital gains would be due when the beneficiary receives it upon death. The issue arises where we see a lot when, an elderly person, they want to move into assisted living, that they can't manage the home anymore or anything like that. What they do is they sell the home to move into assisted living. It'd be a better plan to try to keep the home until death. And then your beneficiaries get the step up in tax basis, where if you sell the home prior to death, you could be, subject to large capital gains taxes, especially here in Colorado, where we've seen real estate, increase in value so much over the years, where, I have a lot of clients who, they bought, the Wash Park home or whatnot for, $100,000,
Right.
50 years ago or whatnot. And now it's worth $2 million. So you have, almost a $2 million worth of gain there. That's all subject to capital gains if they sell. But the idea is if you pass away with it, you get that step up in tax basis, which I think is really important for people to be aware of, which I think a lot of people don't understand or know.
Yeah. So, and I think what you're saying is that individual who owns the home, if they were to sell to use those assets for long-term care, assisted living, whether it's individual or married couple, there's only a certain amount that they can go up to before the rest of it's considered capital gain. So what you're suggesting is that let's make sure that we hold on to that asset. Maybe there's other assets we can consider selling to support this next phase of your life. But like you were saying, if somebody has a $2 million capital gain, and if they're single, they can really only, I think, reduce about $250,000 of that gain, which then creates this massive capital gain expense that they're probably not anticipating. So great point. I mean, I don't think people really are thinking about that. And with all the equity that has been built up over the last 4, 5, 7 years, I mean, these are strategies that I don't think like a legal Zoom would really be telling you much about. You would almost have to find out on your own, and that might be too late.
That's exactly right. Yep.
And it also brings up the question, or not the question, but kind of just when you were talking about, when you're creating these documents, it is a legal document, and not to say that some of these online platforms can't support what it is that you're trying to achieve, but I kind of put it in the same context as like TurboTax. TurboTax is a great piece of software that can help someone who doesn't necessarily have a complicated tax situation and save some money and so forth. But I would say that a lot of us have various things that go on during the year that probably would require more of that professional, whether it's an accountant or CPA. I kind of look at this as the same way. It's like, you can write a will and make sure that you think you've done everything right. But even just having an attorney review it to give their opinion, making sure that you've covered all your bases, probably would be something that a lot of people, a lot of our listeners should really, maybe take advantage of. Yeah. So, Will, that brings up a good kind of example here, is that it's not to say that people can't use those online platforms, the LegalZoom and so forth. I kind of compare it to like TurboTax. TurboTax is a great piece of software to help people file taxes on their own, not having to use either an accountant or a CPA. And if you have a relatively simple tax situation, maybe just W-2, don't have real estate and so forth, it can be a great platform to use and save some money. But similarly, with like your wills and trusts, you can use those online platforms. But as you can kind of see here, there's a lot of things that you have to pay attention to. So even just, writing it out, using those services, but we would encourage you to reach out to an attorney, an estate attorney specifically, and let them review it. Like, just make sure that if they see something that, could cause an issue down the road, that would be well worth your time and maybe even a few dollars for the attorney. But that's just kind of something that I was thinking about when you were kind of going through this, and how important it is for these documents to be as prepared as possible. Would you agree?
Yeah, I think that's exactly right. I think it's one thing to have, a will generated online, and that will may work great, but you want to make sure we've surrounded everything and made sure that, the beneficiary designations, the real estate, everything lines up properly to make sure it's going to the right place.
Very good. Well, I mean, hey, Will, this has been really educational. I think a lot of people hopefully will get some good nuggets out of this, and making sure that they are prepared for that unexpected. Not to say that we hope for that or that kind of stuff. It just happens sometimes, and it's best to be as prepared as possible. Love the conversation. Where can people either get a hold of you or learn a little bit more about your services, Will?
Yeah. So again, the name's Will Morse, and I'm at a small boutique estate planning trust and estate firm in downtown Denver called Bond, Bond, Morse. So Bond and Morse. We've been around since 1988, and our website is bondmorse.com. You can find us there, or you can find me. You can shoot me an email if you'd like to talk further. The phone number is 303-837-9222. Be happy to talk to anyone.
Great. And I really would encourage any of our listeners to take advantage of that. But until the next podcast, Will, it's been a pleasure, and we look forward to speaking with you again, hopefully in the near future.
Yep. Thanks for having me, Neil.